Today, we're going to be talking about forming a limited liability corporation and other legal matters. And the way the agenda will flow is, first of all, I'd like to introduce myself. I'm Monica Mancuso. I'm with St. Mary Excel, a group that's been working in Morgan City since 2018. And we're really trying to follow up on some of the recommendations of a group that came to Morgan City for the specific purpose of helping us grow and revitalize. We'll talk a little bit about the background, and we'll look at this topic, our fourth in a 7 series of seminars. We'll take a few Q&As, and then we'll talk about our next seminar, which is business paperwork and accounting services. So with that being said, this seminar was from this panel visit, and we were actually able to secure some dollars to make it happen. It's called USDA Rural Business Development Grant. We're very excited because our local talent is being utilized, and sometimes we forget at how fortunate we are to have these people return to the community with a degree in finance from UL and a Juris Doctorate from Loyola, and practicing law in this community and knowing this community of the Morgan City Borough area for over 26 years. Our presenter today will be Mr. Gerard Bourgeois. Mr. Bourgeois.
All right. Thank y'all. Like Monica's, Ms. Mancuso said, we're gonna, try to give a basic outline of LLC, limited liability company formation. We do quite a lot of limited liability company formations, most of which are single member or husband and wife. Those are a little simpler. In fact, that's, we can sort of address in general the benefits of an LLC or the first thing, of course, is limitation of liability. That's in the name of it. It's a separate box that you can kind of think of if you have all your assets, your house, your bank accounts, your stock, or the cars, everything personally owned. You have this separate box that whatever's in that box is potentially liable for whatever the services or work that you plan on doing in the LLC you're buying. Another, so limitation of liability is a big positive with the LLC, and different from a corporation that also gives you limited liability, but it's much simpler to retain it. If you have a corporation, you're supposed to have annual meetings where the stockholders get together and approve the actions of the directors approve the actions of the officers, and before big decisions are made, there's supposed to be a vote there could be a vote of the stockholders, or certainly a vote of the directors. Most of the time, people aren't doing that, and it's much easier to lose your protection from liability with a corporation. With an LLC, as long as the public, as long as you act with regard to the LLC. So if we send out on our checks, we have LLC on them, on our invoices, LLC, that they knew on our contracts, the name of the company with LLC is on there. That's pretty much the extent of it. Of course, you have to file your annual report, and those things keep the limitation of liability with an LLC. So we have that big benefit with an LLC without sort of the cumbersome requirements of a corporation that's available for single-member LLCs or multi-member owned LLCs, and that's what we're doing in Louisiana. We're not having stockholder sort of companies where we've got 1,000 stockholders. We have families or a couple business partners getting together to start a business or start a service. So The second benefit, the simple one, is it's simpler to do. So it's almost as easy. I tell people, you can start a business as it gives you the name of a company. It gives you a name for your business, a checking account name. In the old days, you could start up a DBA, Gerard Bourgeois Grass Cutting Services, whatever, and go to the bank and start using that account. Today, you really need a separate ID for the business anyway. It gives you some protection against the name being taken from you by somebody else using Bourgeois Lawn Services or whatever the name would be, and so you can separately identify yourself within the whole state of Louisiana with this filing. And another thing is the cost. So it costs $30 or $35 a year, really, in additional expenses to maintain the LLC once you have it formed. So it's just minimal cost to have this separate business. It's almost, I feel like I tell people I'm almost selling these things. If you're doing business, you should be in an LLC. It's a question of if it's with partners or without partners. First off on the form, so those are the big benefits. You have a limitation of liability, you have a separate account. If you're going to be, another big benefit with multi-member LLCs, you can be treated you can treat the LLC like a corporation, like an S corporation, if it's multi-member as a partnership, or you can disregard the entity altogether on your tax return. So if it's a single member LLC, you have the benefit of just filing the work or the services on your Schedule D if it's rental property. Schedule C if it's work, on Schedule D if it's rental property, and no real extra filings. It just goes on your personal tax return. Even a husband and wife in Louisiana, as a community property state, can file. They can disregard the LLC for tax purposes and just keep it on their personal return, and still keep that limitation of liability from personal liability on things. We were talking about benefits of it. It gives you that name. Most of the time, I've been doing this for 30 years. Twice the Secretary of State's office has given us an okay to file an LLC articles, and the name, the LLC was approved, and then when it got there, they rejected it. But almost always you're safe with calling first and verifying that name's available. That's part of the things that you need to put into your articles. It's real simple. It's the name, it's a purpose, which could be any lawful purpose, and whether or not the company is a limited liability. It's a low profit LLC. That's the only things that need to be in your articles. We put a couple extra things. There's no secretary in an LLC, and so we try to put. But there is a provision in LLC laws that allows you to name somebody as a certifying person in your articles, and we generally put that person, who's going to run it, or just the manager who would be delegated later in the operating agreement. Even though you can put that in the articles themselves, the LLC articles law is very flexible. You don't need an operating agreement. You can just have an LLC, the articles that were filed with the Secretary of State stating that Monica Mancuso is the manager and the member has authority to do everything and certify people, and we wouldn't ever have an operating agreement. We generally do an operating agreement anyway because just in case the the person who's opening up a single member LLC later wants to include partners it makes it easier to do that. It makes it easier to transition the company that Dad was doing other day was carpet cleaning business. He switched to his son. Just transferred the membership interest in that and who the manager was of the company easily with an operating agreement. Yes. You can reserve, if you're forming a company, and sometimes if you're starting a business and you're not sure if you want to go ahead and open that business with that name, but you're doing some planning and doing some studying. Secretary of State's office does allow you to reserve a name for 120 days, and that's sometimes helpful when you're doing the planning that you send in Mancuso's lawn service and make sure nobody takes it while you're getting maybe decals on your equipment or doing different things, kind of getting small things lined up. One of the things another thing you can get your charter revoked for is if you don't have a registered agent. You need to have one registered agent, a person in Louisiana who can be served with a suit or with insurance notice, and that person again needs to be local. If you don't have anybody in the area to do that, there are services that'll do that for you for a charge. And then I had mentioned about the annual report. That comes in quickly after you file 1 year after you file your articles. Generally, the Secretary of State wants to see you confirm the same information. Where's your office? Who's your manager or member? Who's the registered agent? If there was any changes, you need to do that. If you fail to file your annual report, you can get your charter revoked. I'll just flip it through. So LLCs can be member managed or manager managed, and so the difference is we got 5 members. Do we want to vote on everything and have a certificate of authority for somebody to go do ordinary things, or do we want to have a single person who's going to run the day-to-day stuff, or even almost everything. You can delegate to a certain person that he can sell property, or he can go to the bank and borrow money, that sort of stuff. If it's a single member, is okay.
Mm-hmm.
Okay, if it's a single member, it makes it easier. The default rules would be sort of manager managed rather than acting as a member in the company. If you just go into an LLC and you sign that form that's on the Secretary of State's office, you are consenting to equal voting as members. That's the default rule. That's what happens when you file those articles, and sometimes that's fine. Sometimes as a person who's supposed to have 70% interest, but in the company, and who was thinking that his vote counts more, and that's not true. And so that's what it's sort of important to have the operating agreement, so we're clear about who's in charge, what's the members. We'll go through that. I think that's really the next thing, is after you file your articles, the operating agreement can cover capital contributions, so who's the members are, and you can do it differently. So you can do Gerard Bourgeois is going to put up 70% of the capital, or 100% of the capital, but Fred is really doing the work, and he's going to get 30% of the profits, and that's difficult to do with a corporation. You're really not supposed to do that, or can do that. With an LLC, you can change sort of how the profits are divided from the membership, how generally it's if it's 70-30, the person with 70% of membership would get 70% of the profit. in any event, whether it's member managed or manager managed, the party in charge has a duty to deal with the company and in good faith, with the care, judgment, skill of an ordinary prudent person would in a similar situation. That's a kind of everyman standard is what we're looking at there. But that's about the member of when they're running the company. You're not supposed to make a decision that's going to benefit somebody else over the company, in a business decision. So you owe sort of a duty of loyalty to the company when you're making your decisions. There was if there's less than 5 or fewer members, and you're going to delegate the authority, there needs to be a certificate of authority identifying that the member can sell the boat or buy the land, and even if it's member managed, that those are getting to be kind of commonplace now. There's not a lot of formality to them, except it's got to be signed by the appropriate member. And again, we put that in our articles, that there's a person, whether it's the manager or a particular person, has the right to certify the authority of people to act on with regard to the company. And I think I mentioned voting. Voting can be changed. It's always necessary on dissolution or winding up of the company, or sale, or pledge or mortgage of a substantial amount of the assets of the company. To each member, I'm not sure. I wanted to cover kind of getting together the LLC first. The big concerns I always talk about when you get into an LLC, how do you get out of it? If you're putting up money in a company, and I'm working with somebody and things don't go as expected, which is called life. It doesn't always go that way. We want to. I want to know how I get out of the LLC, and so part of the when you're getting into an LLC operating agreement should talk about, and the parties need to know what kind of information is to be shared with all parties. Certainly the regular tax return information, but how much further it goes, that can be in an operating agreement. That can be something that the parties talk about when they're getting into the LLC, how we're going to run things, who's going to handle the checkbook, when do we need to get authority to pay more than $5,000, or is it, some people have on their operating agreement, the members only have to vote on checks that are $125,000 because they're in the big boat business and the engines may cost that much, and other people, the members will talk about every check above $100 has to be signed by 2 people. But that's, those are the kind of things when you're getting in business with people, it's nice to sort of get that clarification about how it's going to go. And then again, we're talking about getting out. And so there's there needs to be a provision in the operating agreement, or like a buy sale, that I'm going to get out at a certain point, or I can if we're going to buy a house at some point in time, we're not agreeing upon how much more we're spending, or the rent's not enough, and I can't ever get to an agreement with my partner or with my partners to rent the property for a better price or do some repairs, that perhaps it's to sell the LLC, that you may want that right to sell the house, that you may want that right to say, look, instead of trying to buy me out or figuring out what the value would be of the company, we're just gonna sell the asset. We're gonna sell the house. And I think that's relevant for this topic or this presentation is if it's almost, people will create single project LLCs when they're doing rehabilitation sometimes, or when they're doing these sort of projects. And it's important, just like anything else, to get a budget your project and how things are going, but if the project isn't going well, if it's going over, is there a way out? Now, you know, with the project that is a rehabilitation project, you know, it may not be as simple as I'm saying, you can just get out and sell the asset. If you're 80% complete on the project, you're not getting 80% of the value. If you try to sell that house, people want to see a finished project, and that's, you know, you can't. There's no perfect document because facts don't allow that. But it is a good idea to go through the steps. You know, in the situation of the 80-20, you know, hopefully when you invest in a project like that may go wrong or have some overages, that you've got enough capital or a friendly loan officer that you don't that you can finish a project yourself and then get out. You know, and your operating agreement should have responsibility for contributions to capital, because if everybody gets together and they say, oh, we're all going to put up 100 grand to finish this project, but that's not in the operating agreement, those verbal promises are not binding on the members to contribute that money to the LLC. And so that's another thing. The operating agreement should bring everybody together on a project like this and make sure we're all on the same sort of pages about the spending and how it's going to be handled, that kind of stuff. You know, it talks about distributions, the rental. You know, sometimes there's a little disagreement about Monica Mancuso is handling all the rent. She thought she was going to get, you know, 20% of the rent like the realtor charges, or 10%, like I should say that's what the realtors charge, rather than an even cut. And the other partner may say, no, that was just part of your job.
It's just movement.
Huh?
We're good, that's just movement.
Okay, I'm sorry. Am I boring?
No.
Okay.
Movement.
Let's see.
Distributions.
Okay, distributions. It was just about, you know, again, if we're going to take disparate distributions, that should be in the operating agreement, or some understanding of that. Who's going to work in the business? Who may be only investing in it? If the person's working in the business and doing carpentry work, remodeling a house, that partner, is he getting salary? Maybe it's a lower amount just because he's a member, but he's getting a salary too. You know, it would normally be appropriate. You know, one big thing too about an LLC, or a nice thing, is if one of the members that you're in the LLC with is that their interest is taken by a bankruptcy court or a bank or in a divorce proceeding, that person who's not signed on as a member of the LLC is only an assignee of the membership interest. What that means is I don't have to deal with my partner's ex-spouse who doesn't, you know, like him or me, but I do have to pay her, you know, 1/2 of her husband's distributions. That's all. So it's distributions, but she doesn't get to vote. Just like the creditor. If I have if I didn't pay my bills and the creditor seizes my interest in the LLC would only have to pay the interest of the dividends that I would have been entitled to, or that the other members were taking. And that is somewhat true of the estate. If you pass away, you're an assignee. And so it's important that the members talk about when they're forming the LLC that if something happens, you know, that buyout clause on death, do they buy out the estate, or is the estate now a partner, a member of the company? You know, and then there's dissolution, which I touched on briefly. If you really can't get along, and we don't have a provision on buyout, or we can't reach an agreement on buyout of the other members' interest, dissolution is an option. That's where there's two ways. One is where you go to court and you get appointed, you present some articles that you want to dissolve the LLC, and we're gonna dissolve and present the debts, present the assets, you pay the debts if you can. If you can't pay all of them, the court most normally lets people pay a pro rata share, and then you walk away. That's again, so if we end up owing $150,000 more than the asset is, there's a procedure to dissolve an LLC that's again protects the individual members from being liable for that judgment if it's done properly. If you voluntarily dissolve your LLC without that protection, you would be personally liable for the debt. So the members would be, and that's not something that people want to that they want to get into that. I think that's a good time for a break. I don't know if you're going to do questions, and then I got an operating agreement we can talk about, or.
Okay. First of all, thank you for that overview, and you really made the point that operating agreement should be nice and clear to start, and that would really ease a lot of the conflict that could arise later.
Right.
And then the thing that hit me the most also was that annual report to the Secretary of State. It's so simple. It's just updating. It's really
right. It's just sending the fee, sign, send the fee, and validate. But if you don't, they can revoke your charter.
Yes.
Right.
So it's really easy and simple. It sounds intimidating. I hate to say it, but when you mention it, it sounded intimidating. And let's say someone that's trying to move from just being a single business owner and now feels like it's time to do more of a limited liability. Is there any kind of measure that you kind of say, advise people on?
I tell them to do that. If you're doing a business, I mean, look, you need to do it. I mean, now sometimes somebody's got a hobby at their house that they've been collecting money here and there on, and selling, I say a hobby, selling, swing sets or something. And they've been every couple of months they make a sale for $400. Maybe that's not the case where you want to have an LLC, but if you want to start doing, kind of step it up. I don't know where that number would be, but it's very low. It's not an expensive process, and it seems like the world's getting more complicated. The banking system almost requires it sometimes. Well, I'll say that. I mean, in the sale of the swings, you wouldn't need it, but if I was going to start an advertising campaign and for selling swings, I would want to have it in the name of the LLC, because if I get really big, that would be the next step. And it's not the LLCs that you do on the Secretary of State's website are actually valid. The ones that will give you a limitation of liability. The ones that people used to do you can still do a corporation on the Secretary of State's website, but that one, it doesn't give you personal liability. It only fulfills one or two of the requirements that the case law requires, 12 or so. But with an LLC that you file in the Secretary of State's office is $110. Now, we don't charge. We charge more than that. Than just the cost of it, because we get the operating agreement, and it's a good idea even if it's a single member, that you can, you kind of structure it to grow if you come in and do it. We'll do the provisions where you can have an operating agreement. That being said, that's not a much of money. Whether it's $110 or $400, it's not a big deal on starting a business. That once it's done, that cost you don't have to pay again until you're just paying the annual fee. If you're in business, you should be able to make enough money. You got to pay the accountant, you got to pay the banks, you got to pay for the cost of those things, and then you got a $35 annual fee, cost. that's added on to it with an LLC. So it's really something that I feel like we're selling to people as a no-brainer. They should be doing kind of any business, except maybe, the really weekend hobby every other month or something kind of thing.
And you talked about LLCs and maybe in rental operations. And then you talked about the death of maybe one of the primary members and then the succession. And is that always spelled out in the operating agreement that takes place, or is that kind of handled when it occurs?
No, it should be covered in the operating agreement. It's not always, like I was saying, there's no perfect solution. The way the court does it isn't perfect. The way that you put in the operating agreement, it's not always, a lot of times people come down to, but you want to get closer to what they want than what's there. If you have a partner who's 40% and you have 60% of membership interest, if you don't have those provisions in there, the estate can be an assignee of the company, of his membership interest, and he may not pay them, their share. He may not, he can change the rules. He's the only one that can vote at that point. Mm-hmm. He's the only real member, and so he can change it so he gets a salary, and then the family doesn't get anything, and that sort of stuff. And most people don't expect that to be the case, but that is the case. That's why they need to, that's why they need to cover that when they're starting up something like this.
Okay. You mentioned that board members are really not needed when you form an LLC.
No, ma'am. That's another nice thing. It's the manager or the members are running it. That's it. So if the manager is delegated certain duties under the operating agreement, he can do those sell property, lease property, buy property, whatever, hire people, whatever those rules are in the operating agreement, he can do without talking to the members. But if it was left to the members, whether the members would vote on something, which is similar to a board of directors. It's just not with the corporation. Most of the time, you had, most of them are single member or two members. You got who are the same person, the two stockholders, the same two directors, or the same, officers. But they, so it kind of gets rid of, I say, some of the not foolishness, but it was just sort of it didn't really help anything. Board of directors is needed in a very company when there's 1,000 stockholders. Somebody needs to run it. They're the ones in charge of it. This is most of the LLCs are the case where the managers or the members have agreed upon a manager amongst themselves, or it's the majority owner is the manager.
Okay. For the most part, that's the questions that have come up before this presentation.
Okay.
And pretty well covered it. I know that, let's suppose I do have an LLC, or I'm thinking about an LLC. That is something that I could come and seek legal counsel on.
Yeah.
And I know through St. Mary XL, part of our USDA grant is going to fund some sessions in which you as a business owner could have some free services, maybe an hour or so, Mr. Bourgeois' time.
If you say so, I think that was the idea.
Yeah.
You were going to approve it.
We have an application, and those applications will be made available to those of you in the Morgan City, Berwick area. And you may have some specific questions that have come today that maybe we didn't cover. But hopefully the overview has been enough to where if you're thinking about creating an LLC that you are, or if you already have one, you can improve that operating agreement, because it sounds like that's the critical piece.
And I didn't know if there was anything about, the development of the area with the LLCs. Businesses create, the more businesses we have, the business growth around here, the better our city's going to be, or the area's going to be. But there's I think one of the questions earlier was about, does the family members who have property in the area, would an LLC help, kind of run that? And the short answer, or there's a long answer too, with the family members who own property in division. I think we all know that there's, like the Lake Lorette field or different places where it started out, 20 years ago, there was 80 members, and then now there's probably, 180 members, and, you'll never get a decision about the property. And so some of the property in town has, 25 members, and 2 of them are in California and don't care about anybody around here, and they don't want to sell, they don't want to talk to them, and that property is out of commerce, and that's a legitimate problem. If somebody's when the aunt comes in now, or grandma comes in now and says, I want this camp to always be for the family, the first thing I'm going to recommend is that they put that in the LLC, just so at some point in time, if the family, by majority vote, decides that we're going to sell it, or we're going to redo it, we're going to make improvements to it, that's all you need. But if you have 25 members, 25 family members who own a house, to rent it, technically you need all 25. To sell it, you certainly do. And if you, so everybody's got to agree upon the sale, which gets to be cumbersome, and property, goes out of commerce in Louisiana as a result of that. There is a way to solve it. It's called a share of sale, and the owners who are present in town or can petition the court to sell that property, because we can't, we want to own it in 100%, and we can't get there without these other owners aren't cooperative. And so, but with that share of sale, you're paying lawyer fees, which get, a few $1,000s. You're paying sheriff's fees, which are a few $1,000s. You're paying, you could be paying surveyor costs. You're paying, clerk of court costs, which are a few, $1,000. It gets up to being. So it's an expensive process, and sheriff sales generally produce a lot lower value than would a private sale. So it's something that I discourage if we can, but it may be the only alternative if the family doesn't have an LLC. So we do recommend that anytime people are going to hold family property, that they put it in LLC. Even if they want to do, it takes 80% of the people to vote to sell mama's house. At least you got something lower than 100%. When it's not 5 kids, it's 3 kids, it's 10 grandchildren, and 2 great grandchildren who are minors, and you got to go to court to get authority to sell something. And so, anyway, that's a good reason to have family property in LLCs.
Yes, because we all, I guess, all trying to work toward the betterment of the Garden City Borough area, and sometimes historically owned properties can kind of encumber its growth, its revitalization, even if everybody has a good idea of how they might move it forward. It's that process of getting everybody on the same page.
I thought that they were going to solve it, or do something to solve it. After Katrina, they introduced the affidavit of small successions, and you don't have to have everybody sign on those to make them valid. And but they ended up, not going far enough. It seems like it would be some quicker judicial proceeding, but. I was saying we have been successful at kind of tracking down pieces over time sometimes, but it's got to be somebody with money. You can't go to a bank and get the bank to loan you $100,000. It's got to be the person who's got $100,000 and starts buying little interest out at $3,000 a pop and paying the lawyer and doing things until it's done. And so it's certainly a problem that we'd like to help solve. But.
Okay. All right, well, that actually ended the questions that had come in before, so we appreciate that.
Do you want me to talk any about this other stuff? I mean, it's formation.
Yes,
I
you
think
want to
I-
take a break or do you
Okay.
want? You want me to put the handout up that you sent over earlier?
Yeah, let's do the operating agreement, that's good. I think the operating agreement part I'll do is,
Is that it?
that's the articles of organization. And so, I guess just for a second, it's still running, she'll just add it out the dead stuff, huh?
Say it again? Yeah, she'll let us out.
Okay. So, I guess just real quick, articles of organization, I just have it of good friends. And so we have two people coming forward, St. Mary Parish are acting as organizers, so they're gonna sign these articles. We have a name, object and purpose is any lawful purpose. And so we may put the purpose in the operating agreement, but we don't generally put it in the LLC articles, because this is all that's required of us, is to state that we can, what the purpose is, just in case we decide to, do something different with the LLC than building swings. If we're doing an active business, the accountants will tell you that we'd like to separate that from a rental business. Rental houses, renting of residences is passive income, and so that income is treated differently. And so sometimes we keep that separate. We do tell the Secretary of State and everybody else looking at it that there's an operating agreement, and so that's going to define who the members are and who the managers are. Paragraph 4 is a paragraph that I say, where there's no secretary with an LLC, but the Secretary of State's office says, well, if you name somebody and you put in your articles that they can do these things, they can establish the membership of any member of the company, or establish the authenticity of any records of the company, or the authority of persons to act in regards to the company, well then, that person can sign a certificate of authority saying that Ms. Monica Mancuso can sell some property that belongs to Good Friends Services LLC, and if she was the manager of this company. And I don't know why they just do a secretary, but they did. And in paragraph 5, we put in there that members and managers shall have the benefits of limitation of liability and protection to the fullest extent allowed by law. And that's generally for single members or husband and wife. LLCs, you can't indemnify a person for their acts, even if it was sort of taking money ahead of creditors, and or sort of more of a gross negligence standard than just a negligence standard. And we would do that for a husband and wife, but we wouldn't do that when they were separate members. And then if we roll on, so this would be signed as an authentic act, signed by the parties. I can move it, I'm sorry. All right, so authentic act, 2 witnesses, notary's signature, they sign it. This is initial report. So we're telling the court, and we're telling the Secretary of State's office where our office is, the registered agent is, the 2 managers of the company, again, signed off by I'm doing it. Registered agent comes up next after the initial report. I'm doing something wrong? Oh, here we go, okay. Initial report, we listed the registered agent, office, and who the managers are. Managers are members, sometimes people can list, the Secretary of State says you gotta list 1 member or 1 manager is at a minimum. The person who is gonna be designated registered agent swears he's gonna accept the appointment as a registered agent. So if somebody got served Good Friends Services LLC, they would good service would be good on Barney Rubble. We have a little letter in the file about to the Secretary of State's office, or starter one, saying that we'd like to get these articles filed. This is the start of an operating agreement. Again, an operating agreement is similar to a partnership agreement, or the bylaws and minutes and buy-sale agreement of a corporation. So there's many different forms of it. We got this from West, a long time ago, and different sections of the operating agreement will change over time. The first part is definitions, which really doesn't matter except for the, sometimes people change what majority and interest means. And so here we had said it's 0.1% would be enough to have majority in the interest, which will matter later for who in here controls the company. But we won't, particularly in a family business. I think I've had families come in and they say, look, we don't want it to be just 51%, but we don't mind it being 65% or 70% or something like that. And then we talk about, the formation of the company. Sometimes the organizer may be, I have Barney Rubble and Fred Flintstone, but it may have been just one of those people, and then it would have been, for 5 other people. And so the organizer, while he's acting in regards to the company, we wanted to give him some protection also, and just say he was acting on behalf of the company, and so we accept that. The term of this is something I missed earlier. The term of the organization is going to be lifetime. There's no end to it. It does matter. Some people who are doing these project sort of LLCs that we're going to rehabilitate Shannon School for apartments. They may say this is going to take 5 years to build this thing, but we're going to terminate it without approval of everybody in 7 years. And so that the people who got into that LLC and pledged to be members may not be able to get out of that LLC for the 7 years. All that capital stays in. They're sort of stuck with it, as opposed to if there's no term of the LLC, if it just lasts until the people decide to get rid of it, well then you can get out earlier. I think this one we just said is gauge and supplies and rental services business, not very clear purpose. Sometimes we're very specific about what the purpose would be. We are engaging in the non-destructive testing of equipment, and so that would later on that prevents Fred Barney from getting into another business that's related to non-destructive testing. And so it kind of focuses the company too, again, about when we get into a business, we want to be clear about what our responsibilities are, Fred and Barney's, and what they're doing next. And this one we put that Fred's got 400 units and Barney's got 600. I think I should have reversed that. I think he's the big guy, Fred. Certificates, we can give people stock certificates. Most people with an LLC don't have stock certificates. Some people like to have something showing evidence besides the operating agreement with those certificates, or there's so this provision is management by the members, which I think on a rental business, owning property, that may be the right way to do it when they decide they want to run things. Majority in the interest comes up again, and so in this case, Barney Rubble could vote every time to sort of direct the actions of the company. And in these deals, alienate or lease the property, mortgage the property, merge the company, incur any indebtedness, expel members. That's a big deal. Do we want that in there? And so sometimes we talked about people with what they want to vote on. What can the members do by vote? By majority interest voting. That's an illustration of that. How meetings are held. If we can't get together, it's not just texting, but you can do it, telephone if that was in your agreements, or by text if you put that in the agreement. It's flexible, but we need to have some basis for it. And I put managers, that handle the day-to-day affairs and do normal things, just both of them. That's not normal. Most people, maybe it's normal for husband and wife, but for as two partners, usually there's some, delegation of duties between the two of them. Somebody's preparing that, somebody's doing the day-to-day thing, somebody's doing the work, somebody, or they may be just invested and there's a day-to-day manager. Paragraph 4, other business ventures. So these people, they can do the same thing, may engage independently with others in business ventures of every nature description. And then opportunities, members shall first present business opportunities of similar nature to the company and adjacent to the property owned by the company. Okay, so this was sort of set up for somebody who was, if we had another apartment complex next door, you had to say, you got a lead on that, you need to tell us, and I get to decide whether I want to go in with you or not in this company. So, some people say, again, if you're doing non-destructive evaluation of materials, the testing or whatever, that you can't do that for anybody else, period, dot. And this one's saying, well, we could own other apartment complexes. That would be sort of the general rule, that people buy these things. Sometimes they'll be in business with that person just for this particular apartment complex, but for other ones they may they can take it out on their own. And that's I say that's a common thing. And then we can really tighten it down so that you can't do any other work anywhere else, that's considered work except in this business. Capital contributions. Remember again, it's got to be in writing what we're supposed to contribute into the company. These are really generic capital contribution rules. It says the members holding 51% can determine how much capital is necessary. If you can't put it up, you're going to have to. You don't do it with 30 written days. The member can loan the money, or the company can loan it for that member's behalf, but there's an interest factor, 2%. Whitney Bank plus 2%, which means it's older. Whitney's it's Hancock Whitney. Let's see. They're going to maintain a separate capital account for the members. Profits and losses are going to be divided in accordance with their membership respect, whatever with your interest. So in this case, Fred will get 40% of the income. Barney would get 60%. And remember, that could be different with an LLC. They could have agreed to something different. Distributions, if and when made, let's see, I wanted to, that's supposed to be in accordance with the vote of the majority of the interest, but we want to give out at least enough to cover the taxes, which right now I think is around 42%. Whatever the maximum tax rate is, if we made $100,000, maybe Fred would be allocated $40,000 of income on his tax return, but the company doesn't give it to him. It may put him in a bind. But so we're asking that the company give out at least the maximum tax rate, so that he can cover his taxes. Books and records. We got to keep adequate business records at the office described in the initial report as the office of the business or on the annual report. Members are supposed to have right to inspect that at reasonable times. They have their accountants do it. There's some tax partnership language there. I don't know if can we open it up a little bit? There we go. And I have on here that bank accounts right now, the initial signatories are the two members. It could be, with from two of the members to sign any checks. And the banks really won't, most won't require, they won't honor the two signature requirement. You still see that a lot, but they want, so companies will do two signatures, but the bank is only going to require one. This is about transfer of interest in the whole next section, and this is again is about how to get out. And so in this case, you would sell your interest to the members at pro rata share, since it's only Fred and Barney in it. That he's supposed to offer it to to the other member first and get 40%, you know, of the fair market value, whatever that was, as determined by the company's accountant, or sort of a review of it. In this case, that you can transfer. We have permitted transfers, should not apply. You could actually give your ownership interest to a trust that's or give the income interest to a trust without violating any terms here. Sometimes we'll put in there, or a lot of times we'll put in there that my kids can, you know, descendants, the section provisions of section 8.2 won't apply to any transfers to my descendants. So, you know, going into a business together, do I want to be in business with the children of my partner? So, you know, sometimes on a rental project that may be yes, no problem. On that welding business, the answer would probably be no. And the parties would want to change the articles to reflect it. If something happens to one of the members on this project, you know, do we how are we going to get bought out? Admissions as a member, you know, they got all the other members. Even if we're going to sell it, we want to some third party. We want to get in this case, they're saying the other member has to approve the other party coming in, and that's not always guaranteed. But that's almost the default rules, and that's another thing we want to talk about when we're getting into this deal. Transferees wouldn't have any, you know, they're an assignee of the business. They don't get to vote. All they get is their allocations. You know, and then we can redeem the other party's interest as long as we pay them that fair market value provided in 8.9. You know, if somebody goes bankrupt, we may want to say that they withdrew. That's additional protection for the company. You know, that they don't have any assets. If they have especially Chapter 7, when they're saying they don't have any assets and they're getting out, you know, above their debts, they're going to lose everything anyway. So we want to take that away. Events of dissolution, basically you're setting somebody up to be, in this case, I made the majority owner, the liquidator, and that person again would gather up the assets and all the debts and try to pay as much of the debts as he could. If there was money left over, that we divided in accordance with the ownership interest. I think this is the statement of it. First, payment of debts. Second, the paying reserves for liquidators. You know, paying off loans of the members, and then it goes to them a share. But that process, again, it limits your personal liability. And then this talks about fiduciary duties, and you owe basically a good faith duty to lawyers of the company. Even though we're trying to limit your liability, you're not supposed to take. If the company owns $100,000 and owes $100,000 to a creditor, and it had, you know, $105,000 in the bank account, and you take for yourself $80,000, that's not good faith loyalty to the company, and you probably have to put it back in. And the rest of it sort of notices. I mean, miscellaneous things, amendments, and how that happens again usually by majority interest and just definitions. But that's an example of an operating agreement. You know what's covered in there. This one seems long. I think it's 15 pages. There's some operating agreements I've seen that are 35 pages. There's it's not supposed to be complicated for the person. It's supposed to be sort of mostly decisions that you know, like again, how I'm going to run my business, how I'm going to get out of the company.
I think that one was kind of comprehensive, and it's always good to have it in writing and planned ahead so that problems are minimized on the other. It just seems to make sense.
Yeah. I'd like to think so.
Yeah.
Yeah, it does, when you plan things ahead, you tend to anticipate problems too, so.
And you've brought handouts that, is this exact same thing that we see on the screen?
Yes, ma'am, operating agreement, and then I had some alternatives in there too, I think. That's the only thing that's not on the screen, that's in the handouts, just different times that we may change the, I think I talked about it. The redemption price can be, that's a difficult thing. You know, we talk about, I want to make it easy for everybody to understand how they get out. If they want to sell their interest, is that possible? Or are we locked into this thing, you know, until the project's done? But if we're going to get out some point in the future, how does that come about? And so we go back up to 8.9. I don't know what they have on 8.9, but you know, this one says the redemption price shall be the fair market value of the member's interest, which is a thing that the accountant determined, right? 8.9. So this and if it can't be agreed upon, so the company's accountant would determine it, and then if they did, and I have a panel of 3 CPAs, one of the company's CPA basically, represented by the member, and then a third party, the accountant should choose that third accountant to kind of determine the fair market value. It's not a perfect clause. There's you know, there's really, it's a difficult thing sometimes on an ongoing business to figure out what things are worth. Some people have, you know, it's 90% of fair market value as determined by the company's accountant, period, or 90% of the company's fair market value determined by the company's accountant of your interest. But if we're still paying off the loan at Hancock or First National, wherever, you know, you're only going to get your contribution back. You know, it could be lots of different things. The important thing is, you know, we got to come up. It's nice to come up with a standard or something that you each approve of individually. Sometimes when the business is first starting out, that's hard. Or again, like the house, it's almost impossible to come up with a fair number there when you're mid-construction. You know, at the end of it, it's easy. It's either appraisal, you know, by a qualified appraiser and a CPA may look at it, is one way, or it's, hey, we're going to sell it, and then we're going to divide it up according to our membership interest. So, again, I just think it's important that we have we look at that ahead of time. That was really the only other thing that I had. So we had operating agreement articles, and I think I sent over the LLC rule. Did I send over? No, I didn't. I can send them if you like. To put up the LLC rules. That was also in that packet.
Okay. Well, we thank you, and we look forward to the conclusion of this series. I think you have one more that's coming up. It'll be on, we'll hit cultural districts and historic districts one more time before the conclusion.
Okay.
So we thank you.
Thank you.